Welcome back yet again, folks. We were listening to some previous testimony in the Chicago murder trial of former police officer Jason Van Dyke, but we want to bring you to another case that we're following here on Law and Crime, and that is the Stanley Liggins case in Iowa. This is the third trial for a man who was accused of kidnapping, sexually attacking, and killing a little girl, and then burning her body near an elementary school. The first two convictions were flipped on appeals, and we have had a series of jury questions this morning. I'm here with Mike Koribanics. He's going to help break things down. We're not sure exactly what's going to happen yet in court. Mike, this could be a verdict. It could be a hung jury. It could be another question. We had a series of questions earlier today. One was about 911 calls. Did 911 calls register on logs back in 1990? The judge just basically said, well, you have your exhibits, review them. That's not uncommon. But gosh, talk about trying to drag up phone call logs from 1990 to the 911 center.
It's really, to me, it's a pretty unbelievable question.
Is it really of essence? Is it really of essence in a case like this? What's of essence is the identification, it seems to me.
That seems to be the whole crux of the defense here, is that it could have been someone else, that there were all these people who weren't really interviewed, or wasn't a very thorough investigation, and what they did investigate, they hid. And to bring up the 911 calls, it really is a little bit perplexing, unless the jury's going towards a position where they did everything wrong in this case, starting from with the first phone call, and we don't have tracks of that. So upon that weak foundation, maybe the state hasn't built. But you never know with a jury. It could be one person, it could be six people. You don't know who's asking the question.
You never know exactly who's hung on the jury until we hear from jurors, which sometimes we do and sometimes we don't. But an update on what's going on. Again, we're talking about the Stanley Liggins case in Iowa. This is a 1990 case that's been tried 3 times now. The first 2 flipped on appeal. We are hearing that jurors have something to say. Is it a verdict? Is it that they are a hung jury? What is it? We don't know yet. We're waiting for prosecutors to get into the courtroom, and that is why we're in a bit of a holding pattern here at Law and Crime. But earlier, Mike, and we've got about a minute left here, but the jurors did come forward and say, we're not able to come to a unanimous decision. What should we do? And then the judge told them to go back in.
That's not unusual. I mean, a lot of times jurors, you don't know, they've been sitting through this trial. They probably want to get home. It's a Friday. But, you know, one person may say, hey, listen, maybe we just tell them we're hung and it's over with. When the judge gives them that instruction to go back and deliberate, in my experience, it really sort of brings the jury back to focus, and you usually don't hear from them for a while afterward.
Some states use it, some states don't. Some call it the dynamite charge because it breaks up some tension in the jury room. Some states say it's a bit too coercive. It forces jurors to come to a conclusion that perhaps they wouldn't have come to on their own. We're going to stand by in the Stanley Liggins case. We're going to take a quick break first here, though, on Law and Crime, and then bring you back if there is something happening live. A recap of what's happened in the Stanley Liggins case in Iowa. Jurors came to the judge not long ago in the midst of a lunch break and said, we want to go home at 3 o'clock to, quote, ease tempers in deliberations. There was a back and forth that you listen to most of here on the Law and Crime Network. The judge ultimately decided she would not grant the jury's request to go home early today to try to, quote, ease tempers. Why is that? The judge said, well, court is open until 4:30. They either need to come up with a verdict or announce that they are hung for good. But Mike Koribanics, look, what do you make of this? Does the jury get a chance to go home early to try to alleviate frustration, or should they be forced to knife through? Or what? How do we interpret this?
I'm a little surprised that a judge would do this. I mean, you got to realize something. Jurors are there. They don't work at the courthouse. They're performing a civic duty. They're involved in the most serious case you can have, looking at putting somebody in jail for life. It's a Friday afternoon. They're tired. It's almost near, you know, the closing hour. I think there's an hour. Let them go home an hour early. Let them regroup. And I think the prosecution should be wary of this, because I think regardless, in the subconscious of all jurors, they always associate the judge with the government. So they may be thinking these jurors are like, the government won't let us leave, and it could come back to hurt the prosecution.
They were really keying in there on this phrase, ease tempers. Exactly what's going on back in that jury room. Are people really duking it out over this case?
Well, I think it's an emotional case. I think it's an emotional case because you have a very serious crime, but you really don't have any serious evidence. And I think maybe jurors are fighting over the fact of some people are thinking, which they shouldn't be doing, with a passion, and others are saying, no, forget about what happened. They don't have the proof of who did it. And that could cause a lot of tension. As a defense guy, that's what you want.
This is a tough case because there is no forensic evidence linking the defendant to the crime, and the eyewitness accounts of what happened at the scene are pretty sketchy. The prosecution has tried to paint this as a lot more ironclad than the actual language coming from the witnesses' mouths. Maybe that's where they're stuck. As a prosecutor, you got to be careful about overselling your case as well.
Well, the funny thing about this case, I mean, I know we spoke about it on this network before, is that it really is almost unbelievable that under the Constitution this guy could be getting retried for the third time. And I think when you say about witnesses, one of the problems is many of the witnesses haven't testified. There's just been investigators from the prosecution reading transcripts of people who are no longer available. I think this case is a big mess, and I think it's a shame that it's going on for the third time.
Yeah, just reading a transcript really doesn't allow jurors to weigh credibility, to determine exactly how the witness was behaving when the witness made the statement on the stand. And that's mostly what the jury's job is. So, bottom line, jurors are going to be held to deliberate until 4:30 Central Time in the Stanley Liggins case in Iowa. A programming note here on the Law&Crime Network, we're talking about the Jessica Chambers case as well. We are expecting the second trial for defendant Quentin Tillis to kick off next week, and we will cover it in its entirety here on the Law&Crime Network. We brought you the first trial in its entirety, which led to a mistrial against defendant Quentin Tillis. He was facing murder charges on accusations that he burned Jessica Chambers so badly that she had burns over 98% of her body. She died later at the hospital, but before she died, she said that someone named Derek or Eric is the one who committed the attack against her. How did authorities get to Quentin Tillis, and are authorities going to clear that up much better the second time around? Those are the big questions that we are watching for. That case kicks off next week here on Law and Crime. Meantime, back to the Jason Van Dyke case in Chicago, where we're talking about a former Chicago police officer being tried on murder charges for shooting and killing 17-year-old Laquan McDonald in the street. The officer originally said that the victim was lunging with a knife towards him, and that's why he had to use lethal force. The squad camera footage tells a different story. Why the discrepancy, and is it that the officer was simply misremembering exactly what happened? Did he perceive something as a bigger threat than the video shows? That's some of what the defense is claiming in this case. Bottom line, let's pick up with our review of testimony in the Jason Van Dyke case. We're going to listen now to an evidence technician with the Chicago PD. Some of the items recovered from the shooting scene there in the Jason Van Dyke murder trial, where victim Laquan McDonald was shot and killed. Mike Koribanics is with me here on the Law and Crime Network. He's an attorney who joins us from time to time. So what do you make of this? I mean, you were remarking there, just watching the bullet fragments and the casings and whatnot go by in those evidence photos. 16 shots. It's going to be really, really hard for the defense to get over the number of bullets fired in this case, because it's going to be hard for the defense to say he was still a threat when he was on the ground and injured.
It's these parts of these type of cases always come down to experts, and experts being, when you look at the video, it's very tough to really differentiate. It looks like he only shot once or twice, but you know, the amount of pull pressure on the trigger. They need somebody to testify to explain to this jury from a defense point is that once those shots start going off, they rapidly go on a semi-automatic and describe the weapon. It's not as difficult to get that many shots off as one would think. The problem here is, though, is that you have someone with no gun, and that does seem like an awful lot of shots. And you have a video that doesn't tell the whole story.
I've asked some other folks this. Do you think the officer is going to have to take the stand in this case to try to explain what was going on inside his own head?
I always think, as a defense attorney, when you have an officer you're defending, you're at an advantage to put your client on the stand because they're trained to testify. They've testified before, not only on their own behalf, so they're a lot more comfortable as most other defendants. I think in this case he's going to have to, because of just all the missing parts of the defense that has to be put through him.
We are curious to hear him in his own words. Jason Van Dyke, the former Chicago police officer facing murder charges in the Laquan McDonald death. This is a case which led to a lot of protests, calls for resignations, and a lot of upheaval in Chicago. We will be back to continue to analyze the case in a moment here on Law and Crime. We were listening to some testimony there about exactly what we're seeing in the video, how it relates to the way the guns work, how it relates to when bullets strike the ground. Mike Koribanics is with me here on the Law and Crime Network. So a lot of intricate detail in there, but it does give jurors an aid in assisting them as to what exactly they're seeing in that recording.
Well, this is a good expert on here. I mean, he's from the FBI. He's got all the credentials. He talks about how he teaches classes, things of that nature. But, you know, one of the things I couldn't understand with, sometimes I think they overdo it is, I mean, he's talking about how you can't decipher the shots from the video and all that, but all you got to do is look at the physical evidence and see the bullet casings that are there, and you know how many shots were fired.
Yeah, I mean, in other words, the video doesn't show literally every single shot clearly. I think he was trying to make that point, but it could have been made that succinctly.
Correct. But sometimes these experts like to be a little bit verbose.
Well, and sometimes attorneys like to make sure that things are crystal clear on the record, and they want it out in a certain way and in a certain language so that they know that the record's really clear. They're putting a piece of evidence in with arrows on it to act as an aid, saying, well, you're going to see something here, you're going to see something here. They don't want that to get confused with trajectory, because there were objections about whether or not another witness was properly accredited by the court to be an expert in trajectory, and then that all caused a mess. That witness had to come back and testify in a much more limited way. Perhaps some of the clarity here was an attempt to clear that up before that problem reared its head again.
There's always a danger, though, of doing that, because a good defense attorney will go after that and say, listen, you're here to use common sense and reason. Why is the government producing so much? Why are they giving you such a hard sell? Because maybe this case is not as good as it looks. That's always a problem.
Now, one thing that this witness did get into is just say, hey, look, one thing I can't really testify to directly with my expertise is exactly what was striking the victim. Was it an actual bullet, or was it something ricocheting off the ground? Because as a bullet strikes the ground, it tears up the pavement, and then it sends little chunks of asphalt flying.
Well, I think they're going to be able to clear that up with the medical examiner as to what the injuries were, whether the bullet was exiting, coming back, or if it was a ricochet wound, things of that nature. I'm sure this is going to be a case with a lot of experts, and it's just a very sad case for that young man on the ground. And
it has been a case with a lot of experts leading up to this point. The state wrapped up its case in chief yesterday, I think it was, in the Jason Van Dyke trial in Chicago. Former police officer on murder charges with accusations that he intentionally shot and killed Laquan McDonald, 17 years old, without proper justification. We've been playing the video over and over again. Experts have been on the stand for the state to explain what they think it means. The defense says that there's a lot more to the story, and we'll start to hear that next week. In the meantime, we're going to take a quick break here on Law and Crime, and we'll be back right after this. That was our point-counterpoint analysis of the opening statements in the Jason Van Dyke murder case out of Chicago. Mike Koribanics is still with me here on the Law and Crime Network. You're a former prosecutor, current defense attorney. You've sat in both of these chairs in similar cases. How do you sum up what we just heard?
When he was talking about the knife, the defense attorney, it's a little surprising to me, because I think that hurts his case. In fact, I prosecuted, before I was a defense attorney, a shooting with a police officer, and he took the stand. And his statement was, when a guy was smoking crack, when he turned, he saw the light and thought it was a gun, and he shot. The guy wasn't killed. The difference was, though, on the cross-examination, he said to the victim, do you know I could have you arrested for this? Which then we argued in front of the jury was, he knew it wasn't a gun. He said he could have you arrested for it. So right now they've just conceded we knew he didn't have a gun. And force can only be met with like force. A knife and a gun is an unfair fight.
Well, you know, is it one of these things where the officer could say, you know, look, I heard the reports that he had a knife. When I saw his arm come around, I was fearful that he also had a gun.
That's a little bit of a stretch. And you would think, as you look at that video, that the officer would have approached with much more caution if they thought he had a gun than coming right up and at him. They're going at him as he's walking away. And if you thought he had a gun, I would think you would hide behind the truck to give yourself some protection and see what's going on. This seems like it was a little bit of a rush to judgment on the street.
That's a really great point. You know, why were they out in front of the truck and not behind it? I haven't heard anybody analyze that, but you're right. That adds another element to this that would be a strong argument for the prosecution to make here. Again, folks, we're talking about the Chicago murder trial of a defendant who is facing charges that he unreasonably used deadly force to take down that suspect who was walking in the middle of the street. The defense says there's a lot more to the story. We're going to continue to analyze this when we come back. That was the prosecution's use of force expert in the Jason Van Dyke murder case out of Chicago. I'm still here in our studio with Mike Koribanics. Mike, you really keyed in there on the expert's discussion about the taser being something that was proper in his opinion. Why did you key in on that?
Because I think it's very interesting, because what I understand of the testimony that's gone through is prior to the officers coming onto the scene, there was a dispatch to bring a taser unit. And that sort of should be to any trained officer that we're not in a life or death situation. We may have someone who may be acting peculiar, emotionally disturbed, EDS situation, but we don't have someone who's a threat. And the very fact that the way this comes, when you put that in the whole context of everything we see on that video, it does seem to reinforce this expert that he really acted aggressively. The police officer acted aggressively in all he did when all the warnings were really stay back and let's see what's developing. And quite frankly, it's a little disturbing too when you really focus on that video. Is it's a well-lit area. It's a well-lit area. We see that video very well, and we see everybody in it very well. So those on the scene had the same opportunity, and I think that hurts the defense in this case.
I think it does as well. This is a tough case for the defense, but I'm certainly waiting for the defense to get its expert up there and start pointing to other things. And if the defendant takes the stand, which a lot of us think he might, or it's likely that he will in this case, that might knock this into an entirely different ballpark.
That's true. That's true. But the problem is it appears that right now the state is getting a lot of momentum. This expert I thought was very effective because he really looked like an old school law enforcement guy. And I think the juries understand about the blue wall of silence. And for someone to come forward and testify against another police officer, and he did seem hesitant, quite frankly, it speaks volumes even more than that testimony.
Well, not only that, but you've got a prosecutor who's used to working with this department, who's now up there giving an opening statement to jurors, bashing at least one officer in this department. That certainly changes the dynamic in a case like this as well.
Well, I think it adds credibility to the prosecution in this case by the very fact that they brought these charges, and it's just a sad state of affairs where we're at with these police shootings, and I give this prosecutor's office credit for coming forward and putting on this prosecution.
It's going to be an interesting case when it picks up with more live testimony on Monday. The state rested its case. Today, the court is dark. No testimony today. The defense is going to be back with its case in chief on Monday. The defense for Jason Van Dyke will certainly be interesting. He, of course, is the Chicago police officer accused of firing 16 shots, basically emptying his magazine, causing 24 total wounds in 17-year-old Laquan McDonald, the victim, who died either at the street or on the way to the hospital, depending on different theories of the case. We will be right back after this. So this officer had his weapon drawn but never fired it, and that is a sharp distinction from what the defendant in this case did. Mike Koribanics is with me here. He's a former prosecutor, current criminal defense attorney. Should jurors credit this guy as the level-headed one in that situation?
Well, this officer right now is testifying is going to have a big impact on his jury, silently. They're going to compare his actions and the other actions, as you pointed out earlier. There were more than 2 police officers there, and there were a lot of communications going on. So it's very difficult to understand for a jury, I would think, is why this guy? Why wasn't everybody shooting? And why did he feel such a threat when they had so many people around him? And was his actions reasonable?
Now, certainly the defense will get up there in closing arguments and say, now, never mind this other officer or any other officer, because they weren't in the exact same position that the defendant was. And I'm sure that will probably come out at some point, if it has not already.
The problem with that is that's a that's a very dangerous position to put yourself in as a defense counsel. This case is all or nothing. Either they're going to acquit him or not. If you're saying that he acted not intentionally, then we don't have murder. But if he acted negligently with his training and experience, you still have someone up for a manslaughter charge, which is heavy time.
It is, but look, I mean, you know, we also heard the defense say, well, they could have charged him with excessive force or something like that. I mean, is there another charge in Illinois, a lesser charge that the defense is going to try to concede here to try to deflect the murder charge?
I would think they're going through that analysis, but at the end of the day, it's really your client who really says what he agrees for you to do in his defense. And it appears here this is an all or nothing case in my estimation of what I've seen.
Yeah, I mean, I could see that as well, because if jurors are willing to convict, they might be willing to go for the whole enchilada in this case. Of course, we're talking, folks, about the Jason Van Dyke murder case in Chicago. It's silent today, no testimony in that courtroom today, but we'll be back with the defense case in chief on Monday, and it is certainly a hotly anticipated defense. This case involves charges a Chicago cop shot and killed a victim without justification. Back after this. We're listening to key testimony there in the Jason Van Dyke murder case. Mike Koribanics, appreciate you joining us here on the Law&Crime Network today.
Thank you for having me. Always a pleasure.
Okay, we're going to wrap things up here from my time at the Law&Crime Network. Jesse Weber will be next here with the Reverend Jesse Jackson, who himself made a decision to attend key portions of the Jason Van Dyke murder trial in Chicago. Again, we're talking about the case involving a former Chicago police officer who's facing murder charges related to what prosecutors say is the unjustified shooting of 17-year-old African-American teen Laquan McDonald. Jesse Weber will be here after the break. I'm saying goodbye. I'll see you next week.